Ursula Orr, CR 2014-124-175-001, appearances, please.
Good morning, Your Honor. Kelly Neal for the state.
Elaine Ruggie appearing on behalf of Ms. Ursula Orr, who's present out of custody and standing at the podium.
Mark Benjamin Taylor, behalf of Ms. Orr.
Ma'am, your name and date of birth.
Ursula Orr, April 15th, 1980.
Thank you. How are we proceeding?
First of all, the state's going to dismiss counts 1 and 2 off the direct complaint.
All right, and I assume there's no objection?
No objection, Your Honor.
So order dismissing counts 1 and 2.
Your Honor, we'd like to approach with a 3-page document that change of plea and waiver of the
Thank you. Ma'am, I've been handed a plea agreement which indicates you intend to waive your right to trial to plead guilty. Is that what you intend to do?
Indeed. Yes.
How far have you gone in school?
PhD.
Do you read and understand English?
Yes.
Have you had any alcohol, drugs, or medication in the last 24 hours?
No.
If you look at your copy of the plea agreement, is that your name in the upper left-hand corner?
Yes.
Are those your initials down the left side of pages 1 and 2, your signature on page 3, indicating you read this plea agreement and discussed it with your attorney?
Yes, it is.
Do you understand the plea agreement?
Yes, I do.
Does it contain everything you've agreed to with the state?
Yes, it does.
Is there anything in the plea agreement you do not agree with?
No.
Your plea agreement indicates you'll be pleading guilty to count 1, resisting arrest, a class 1 misdemeanor, committed May 20th, 2014. If you choose to plead guilty, you will be giving up the following constitutional rights. You are presumed innocent. You have the right to deny the charges and to have a jury trial where you would be represented by counsel. At trial, you could not be found guilty unless the state proved the charges against you beyond a reasonable doubt. At trial, you would have the right to cross-examine and confront the state's witnesses through your lawyer, the right to compel the attendance of witnesses on your behalf, the right to present evidence in your defense. You have the right to testify yourself, but you could not be forced to testify, and if you decided not to testify, that silence could not be used against you. You would also be giving up the right to any sentencing aggravating factors determined by a jury. By entering into a plea agreement, you would also give up the right to a direct appeal. Your only remedy would be a petition for post-conviction relief. Further, if you're not a citizen of the United States, pleading guilty may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. You understand those rights?
Yes.
And you understand the potential immigration consequences?
Yes.
I'm now going to go over the sentencing ranges for a Class 1 misdemeanor. The maximum penalty is 6 months in the county jail, a fine of $2,500 plus surcharge, and you could be placed on probation for a period of up to 3 years. If you're placed on probation, there is a one-time $20 probation surcharge. If you're fined as part of your sentence and your offense occurred after July 20th, 2011, there's a one-time $13 assessment to the investigating police agency. If your offense is a drug offense, which is not applicable here, restitution for economic loss to any victim is also required. The court may order restitution at sentencing or at a later date. The court may issue a criminal restitution order. When a criminal restitution order is entered, interest will begin to accrue on the amount ordered. Additional fees and assessments may be imposed, and liens could be placed on your property. If you plead guilty today and your plea is accepted by the court, you will not be allowed to withdraw from your plea unless you can show a manifest injustice. You understand that possible range of penalties?
Yes, I do.
Your agreement with the state is that you'll be placed on supervised probation. You'll pay restitution to all victims included in ASU Police Department number 2014-000385543 and supplements for all counts, regardless of whether amended or dismissed, for all economic loss in an amount not to exceed $15,000, and you're to have no contact with the victim. In exchange for those stipulations, the state agrees to dismiss count 2. Is that your understanding of your agreement with the state?
Yes, it is.
Ma'am, understand if I find the stipulations to be inappropriate, I could reject your plea of guilty. If I do that, I will give both you and the state the opportunity to withdraw from the plea agreement. You understand?
Yes.
If you look at paragraph 5 on page 2, you avow you have no prior felony convictions, you are not on probation for conviction of a felony offense or a misdemeanor offense, and you are not on parole, work furlough, community supervision, or another type of release or escape from confinement for a conviction of a felony at the time of this offense, and you have no other pending felony matters. Are those avows true?
Yes.
Ma'am, has anyone forced you or threatened you in any way to get you to plead guilty?
No.
Has anyone made you any promises not contained in your plea agreement to get you to plead guilty?
No.
How do you plead to count 1, resisting arrest, a class 1 misdemeanor, committed May 20th, 2014, guilty or not guilty?
Guilty.
Dr. Bates.
Your Honor, on or about May 20th, 2014, Ms. Orr was within the county of Maricopa, which is within the jurisdiction of this court. Ms. Orr was stopped on a closed roadway by ASU Officer Farron, a person reasonably known to her to be a police officer acting under his official authority, who demanded her physical ID, which she was under no statutory duty to provide. Officer Farron placed her under an arrest which she maintained was unlawful. Ms. Orr intentionally attempted to prevent him from effecting this arrest through passive resistance with absolutely no force used, which under Arizona Revised Statute 13404 B2 is not a defense to criminal liability for resisting arrest alone.
Have you heard what your attorney said? Are those things true?
Yes, they are.
Either counsel have any concerns regarding factual basis or voluntariness?
First of all, victim rights have been complied with, and second of all, whether or not she believes the arrest was valid or not, she was not able to resist, so I'm looking at that.
Thank you. Court finds defendant's plea is knowingly, intelligently, and voluntarily made. There's a factual basis for the plea. It's accepted, entered of record. This is addressed to both counsels. The way that the plea is written is it's listed as count 1 and count 2, showing that count 2 is being dismissed. That's not the same count 2 that you just dismissed, correct, counsel?
No, on the information, counts 3 and 4 from the direct complaint become counts 1 and 2, since I dismissed them previously.
Okay. Is there any confusion on your part, counsel?
Okay, and just to clarify, Your Honor, the counts 1 and 2 that were originally dismissed prior to plea by the county were the obstruction of a public thoroughfare and failure to provide ID, making count 1 the resist arrest and any information.
All right, and count 2, aggravated assault, will be dismissed at sentencing, correct?
Yes, and that's reflected in the information.
All right. Defendant's plea is accepted, entered of record. Order setting sentencing on August 1st at 8:30 in the morning. A criminal history is ordered. Anything further?
No, Your Honor.
No, Your Honor.